license to permit. But in a couple of the sections here, it then left with license as opposed to changing license to permit, to permits. And I didn't know if that was an oversight or whether that was on. Okay, for instance, go to shellfish conservation, chapter 127.
What'd you say, Sheila?
Shellfish conservation, chapter 127.
Yep.
For instance, it says town clerk shall issue licenses to residents. Should that be changed to permits? Because in other sections, you're changing license to permits. The word license.
Right.
And same down in business on public streets.
As for the shellfish licenses, they're actually called licenses. We've always called them that. So I'm not sure changing it to permit makes sense, but I can definitely look into that.
Yeah, I was just curious whether you noticed it or whether that was an oversight. That was my, yeah.
Well, and I think that under chapter 147, as Sheila says, it says the fee shall be $50 per license. And we're taking that to the permit fee. So, I mean, Amy hasn't reviewed these yet. The attorney for the code company has. So
Yeah.
That's a great question that Tracy can discuss with Amy.
Yeah.
Right. And then just go up to chapter 110, same page, on top of the page. The definition of renewable energy installation is amended as follows. Renewable energy installation. I mean, it's the same wording. So I didn't know.
Okay, I can look into that.
Yeah, and it seems to be, it's naming like absolute systems. I wonder if we should allow it to be, like all energy relatable items so that we don't have to pick out different ones.
Okay.
Do you know what I mean? It seems like we're limiting it to
something broader, you're saying.
Yes.
Okay.
And if we want to do that.
Maybe we should bring Werner up as well. Is Werner out there? Yes.
Got
To
one.
see if he
Chapter
has any.
61, harbor and waterfront. There's a definition of lobster buoys, and then the act to prohibit lobster fishing in the harbor from basically from Monument Island all the way out to the Bell Buoy. You might as well just throw that out because they've been trying to do that since the 1970s, and it's unenforceable, and the Coast Guard has ordinance for it. I don't think we should be going down that road because I think that you may end up with some unintended consequences.
So that's the prohibited act section, Ed?
Yes, yes. They have been trying to do that since I can remember. The Coast Guard says you can't fish in a navigable area. So I think that for the town to be involved in this may cause us some heartburn down the road. Heck, I got gear in that area right now. And people like to fish there because that's a good place to find out when the shedders are coming out, which is a way I try to gauge my season as things, move on. And everybody knows you don't fish any good traps in there because you'll lose them.
I can't.
Remember that, Alan? Way back in the day, they were fighting over that when Hale was the year manager.
No, I think that was before my time.
I was just
Yeah, I remember it
I
quite
remember
well.
it.
Yeah, I remember it quite well. The Coast Guard came in, they were gonna go ahead and drop a line across from boat to boat and clean the harbor out. They never did. So.
No.
Werner,
They'll never-
did you have any feedback on chapter 110, the property assessed clean energy, or?
Let me just pull it up and take a look here. This is in chapter 1.
Yeah, Sheila was saying that Or it's on page 8 of the document Tracy gave us. One note that Pat had brought up earlier today was on page 4, under section 1-9, when it talks about the violation and penalty for tampering with the code. And he thought that the fine of not more than $100 was probably minuscule. And I spoke to Alan before the meeting, and one option would be to have like an amount for a first offense, like $100 for the first offense and $250 for the second and $500 for the third. So at least multiple offenses, it would grow.
Does the state not give any guidelines for that?
Not in this particular case.
What do they mean? What by altering or tampering with code? What does that mean? How can somebody alter or tamper?
So if somebody took our code and then they, took it from a PDF or electronically and they set it in a different document and they changed some of the words and then they represented that was the code and this was the ordinance of the town, that would be tampering or altering it.
Thank you. Thank you. Yeah. Yeah, that makes sense to me. Having it grow,
Yeah, $100 does seem a bit low in this day and age.
I'm fine with it.
And the other thing that I questioned in some on these pages is changing it, having an actual penalty to, it's going to be up to the Board of Select. So are we still going to, at the beginning of the year, decide the fees are going to be stick to that? Because I don't want it to be, like, oh, somebody did something wrong and now we have to come up with a penalty for them. I'm hoping.
See, you're breaking up pretty bad.
I am.
On my end, yeah, you're cutting in and out, and I'm only getting every other word.
Well,
Sheila was asking about fees and fines and penalties and whether or not the board would set them. So, I mean, the fees, most of the fees are being removed from the code and the ordinance language. So we'd have a fee section, but then fines and penalties are usually a part of the ordinance or code. So those are set in here. So if it says something like $100 per day per offense, then let's pretend there were 10 offenses and they went on for 9 days. The board would have some leeway about whether to have the maximum penalty or to minimize that, because they always have the ability to enforce that. But yeah, the base penalties are set in the ordinance.
Okay, the base is set. Okay.
I like that better. I don't want to have to feel as though we need to make it up as we go, because I'd like to see our ordinances and our fines, when it's unfortunate that we have to do that we have a basis and everybody's treated fairly.
Right.
Any other questions on this?
Werner, did you have anything to add on the?
Yeah, so I just looked at the property assessed clean energy section. And so from what I can tell, the only change to the renewable energy installation definition is that it includes, well, they're essentially modifying the definition to include masonry stoves into that definition, but it otherwise remains pretty largely unchanged.
So I'm not sure, what's a masonry stove?
A masonry. Yeah,
Like a
I think.
fireplace?
Yeah, I think that's what they're referring to as a fireplace. Yeah.
Oh, okay.
Why don't they just say fireplace?
But why do we have to limit to the particulars of in that paragraph? Because my thought is, within the next 10 years, talking about renewable energy installation, there's so much more happening. And if we qualify it by mentioning certain things, that we'll have to come back in 5 years and say, okay, we have to add this or we have to add that. Couldn't we just call it renewable energy installations, and give an example?
So, it's a pretty broad definition to begin with, and so I think this definition already exists somewhere, and so it's a pretty limited change. I will point out that it does, at the very end of it does say, and any other system eligible for funding under federal qualified energy conservation bonds or federal clean renewable energy bonds. So there is somewhat of a, I guess I'd call it a catch-all, at the end of the definition, that, it keeps it fairly broad.
I think that's what Sheila was looking for, so it's already there?
That's right. So it gives you the specifics, so it talks about, that it kind of gives you some general, some general language there, but then it also says including but not limiting to, and then it calls out the specifics, photovoltaic systems, so, basically solar panels, solar thermal, biomass, and when they're talking biomass, that's the change, is that, I think they got specific to make it clear that, like, a fireplace or wood burning stove all is technically a biomass. You're burning wood in it. That's what they're calling out.
And this is the PACE program, this ordinance.
Right.
And this goes back to the state program that allows homeowners to borrow funds for energy improvements in their homes. So it's not really much of a local ordinance. It just allows our residents to access those loans by having this ordinance on the book. So it really ties back to the state definition.
Right. Yeah. This isn't coming out of zoning.
Are there any other comments on this, or?
Are you
On
okay
the
with that,
ordinance?
Sheila?
On the ordinance?
On the
this-
codification, yep.
Yes, I got a question. On page 6, Sheila has addressed the other questions that I've had, and I didn't know about Ed's, but I understand what he said. But on page 6 at the bottom of the page, I just want to know how we identify a service dog. That's been added, and we already have enough feces left around the town already. You can see it walking up and down Pier Road on any day. What is a service dog? I know I understand the need for service dogs, but like everything is not a service dog and it's not identified as such. What do we do?
Well, I can tell you that at the hotel, we have to take a service dog. We do not take an emotional dog, an emotional support dog.
Right.
And those kinds of permits you can get right off the computer. They walk in with little licenses. As a service dog stays right beside their owner. The dog does not go anywhere else. If you're the person with the disability, that dog stays by your side. An emotional dog, however, you can put it on a leash and it can go here and it can go there and you can pick it up in your arms and do all that kind of stuff. A service dog stays by your side. That's the difference.
Yeah, but they don't. So I know, but I've been on an airplane when somebody comes on with a service dog that's not call it a service dog, not a service dog, and they've been meant to come on. I'm not trying to say we don't want to have something for service dogs. All I'm trying to say is, how do we identify it?
Doesn't the state or the federal government have a definition
Yeah,
They do have to get a certification. They have to carry with them at all times. And if to register it as a service dog, they have to have that registration paperwork. We did talk about this, adding this line quite a bit in the office, and basically, and I talked to the codification people about it, and basically it's just bringing us into alignment with the ADA requirements and laws.
Yeah.
So it's just to cover ourselves that we are trying to make allowances for that, and we can't force someone who has a disability, like if they're in a wheelchair or something like that, and have a dog. Yeah.
Yeah.
So we did talk about it a lot, and I believe I even talked to Amy about it, and she said that we should keep it in.
so the
Okay.
definition under Title 24A, it says a service dog means a dog that meets the definition of service animal set forth in Title 5, Section 4553, or assistance animal. So Title 5, 4553 says,
Sounds like this is above our pay grade as far as
Yeah,
us, trying to figure out what, I agree with you, Mike, because I've seen these people, oh, this is my service dog, and darn well it isn't. It's as Sheila says, an emotional dog.
yeah. I don't want to belittle the point. I just wanted to know, I'm not going to walk up to anybody and say, is that a service dog? It's just not going to happen, but.
Right.
A lot of them say service dog on them so people don't go and pet them.
so here's the definition under Title 5. A dog, or it can be an animal, that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability.
Okay.
It says other species, whether wild or domestic, trained or untrained, are not service animals for this definition. I know that the police have had quite a lot of legal discussion about it and what questions you can and can't ask under ADA. And they can ask the question, what is this animal trained to do? What is this dog trained to do for you? And somebody should be able to answer that and meet that.
Well, like I say, it was added in and it was new. And I know that the service dog thing has been abused, and
Yep.
I don't want people who need it to not have it. I just want to, like I say, I'm not going to walk behind anybody and say, is that a service dog? Not my
You might
issue.
not want to walk behind a service dog, Mike.
Yeah. So, okay, thank you.
So I guess we're ready for a motion.
I thought aren't we gonna discuss this some more?
Oh, you're not finished?
No, but I mean, in the normal, before we put it out to vote in October, we see things more than once before we agree to put them on the ballot.
So
Yeah.
what will happen next is it'll go to Amy for her review.
Yeah.
So if, you will see it again.
Because I would like to strike the harbor part. Because I'm not going to vote for it if that's left in there.
Are we allowed, Ed, do you think we're allowed under law to, if it's a national law, are we allowed to strike it and not follow it?
I don't know if we're allowed to. It's never been there before. I mean, it's a legal question, but I think the problem, Mike, and you may be right. We may be stuck with it, but I think it's going to cause us more heartburn than good if we put it in there and we don't have to.
Okay.
Because I wouldn't want to be the harbor master and have to enforce that, because he'll be one very unpopular person.
Lori, do we have to vote on this tonight? Or do we
I
have-
just want to make sure that we're in agreement that this will go on the November ballot in some form,
In some
Because-
form, absolutely.
because I don't want to have Amy review if you guys are in disagreement. This is about a check-in. So normally, you're 100% correct. We will go through legal review and we'll bring it back to discuss each and every time until we get ready for the warrant.
Okay. So what you're saying is we don't have to vote on this tonight. We can go ahead and wait till we get,
We don't, but I am looking for some, acknowledgement that yes, this will go on the November ballot with changes between now and then.
does somebody else want to make the motion to that
Aye.
effect?
I move that we move forward with this, with the option that we will be able to change it in the future. You know,
I have a,
through our regular process.
I have a first. Do I have a second?
Second.
Mike seconds it. Any more
Okay.
discussion? Hearing none, I'll take a roll call. Sheila?
Aye.
Pat?
Aye.
Ed?
Aye.
Mike?
Aye.
Alan says aye, motion carries. Okay, approve Board of Selectmen regulations as part of the codification.
I make a motion, we accept it as written.
I have no questions.
I have a first. Sheila seconds it. Any more discussion? Hearing none. Take a roll call. Sheila? Sheila?
Aye. Aye.
Pat?
Aye.
Ed?
I'm trying to figure out where we're going here. So I got number 5. So we're talking about we're talking about Goose Rocks Beach.
Right.
Aye.
Mike?
Aye.
Alan says aye, motion carries. Consider adoption of emergency management ordinance. I'm gonna pass it over to you, Laura.
So this is another ordinance that Amy originally drafted, and we have for the board for discussion about the November ballot. And whether or not you want to move forward with this, whether there are more questions or not. I mean, basically, the ordinance allows us to create and designate an emergency, and what the powers are is the town manager would consult with the chair of the board and could declare an emergency for up to 5 days. After 5 days, it needs to be renewed or extended by the Board of Selectmen. So these are all choice points. You know, you could not have the town manager have any authority. You could have the board have to require it. You could give the town manager total authority to set the emergency. Amy chose this path because it seems to be the most common in the ordinances that in other communities she's seen, but it's not the only path. So after 5 days, the board would have to have met in order to keep it longer than 5 days. We also put it in that it would not exceed 30 days, but that's another option. You could declare an emergency and keep it an emergency until you vote otherwise to terminate it. My concern when I talked to Amy about having the 30 days in there is it creates a check-in point. So otherwise, like the pandemic that we're in now, you know, usually you think of a hurricane or a blizzard or something that's much shorter duration. But with this, if we just set it and then a year from now we were going to relinquish it, it might just become so normal we forget to ever terminate it. And so I thought maybe a 30-day check-in would be good. But those are all decision points that you guys can give feedback on.
I have no questions. I have no questions at all.
I just think the only thing I had with it was I think 5 days is kind of short.
I agree with Ed.
I agree with Ed.
I had the same question.
Because 5 days could fall, you know, you could have it on a Tuesday and then you got to be meeting on Saturday.
Yeah, so what's a
know.
time period you guys would like to consider instead?
I was thinking at least a week.
Mhm.
Full
I
week.
was thinking 2, but I could live with a week.
7 days?
Yeah, something so that if we did it on Monday, we would at least be back the following Monday, or 2 weeks from Monday. But I'm good with a week.
Do you want to do 10 days?
No,
Yeah.
because that might actually put you on a weekend again.
Why don't we do 2 weeks? That sort of solves the problem. It gives us flexibility.
I'm flexible on that as long as it's like at least in an increment of a week. 1 week, 2 weeks, 3 weeks, etc.
All right, so what do you guys want?
2,
I'll let Mike and Sheila and
I'm
Pat talk about it.
My initial thought was that we just take the 5 days out and we leave 30 days. And we can always, is saying not to exceed 30 days, but you can always meet within that 30 days and end it. You know what I mean? So I just thought that the 5 days and the 30 days was confusing to me. But
I would think that we'd be able to end it anytime we wanted to.
Exactly. That's exactly right. That was
Within
my
30 days.
looking at the time, you know, I say, why do we need 2 weeks or 5 days and then 30 days? We can actually vote to end it anytime that we want. It says that unless extended further, it can't expire or whatever. I don't think we need to put a day limit on it in the interim.
Well, the first emergency right now is the town manager with the chair sets. And so that's the shortened window. The 5 days is only for that one. And then the board would have a 30-day window, but that's part of the question. Yep.
So you're saying that after 5 days, the full board's gonna have to vote on this?
That's the
Okay.
way the ordinance is written right now.
Okay.
Kittery, for example, the town manager has all the authority to set the emergency and to keep it going and to set rules under the emergency. I mean, that's one end of the spectrum.
I see. Yeah, I didn't understand that way. Yeah.
Sheila?
My comment would be, because we're allowing the town manager and the chair of the board to determine the emergency situation and things that have to go on, would it be better, say, for the two of you, if we allow the 7 days, we all come together as a select board to either respond to you or say, you're doing a great job, we're with you 100%, so that you guys are not taking the brunt of it, that it becomes the board. That was my only thing. If you don't think it's to, then it's not an.
I think that's what this is set up to do now, right, Laurie?
But only 5 days.
Right,
Yeah.
I mean,
That's
I
the
know-
way it's set up now. And so
Okay.
I think, I try to look at not the people who are here currently, but in the future, what kind of scenarios could come about. And so I think it's important for the board to have buy-in to, if it's going to be a longstanding emergency provision, and it's a check-in. So if you have a chair that's at odds with the board or something of that nature on a particular issue. So I think having some ability to react quickly and take action that would be helpful for some period of time. So if it's a blizzard or a hurricane and you just get some roads that need to be closed, you could have a week to take care of that. But if it's something longer than that, then probably the board should be involved.
so let's just change it to 7 days.
Works for me.
That works.
Yeah.
okay.
Well, I move we accept it as written with the exception of section 6, letter B, changed from 5 to 7 days.
Hey,
I have a first and a second. Any more discussion? Hearing no discussion, we'll take a vote. Sheila? Sheila?
Aye.
Pat?
Aye.
Ed?
Aye.
Mike?
aye.
Alan says aye. Motion carries. Consider land use ordinance amendment regarding tents.
Okay, one comment. One of the things I mentioned, and I'm not going to fall on the sword over this, but one of the things I mentioned, it's helpful for the restaurants to have their tents up in May when it's still a little chilly and people could be under a tent with sides and be relatively comfortable. The same with September. So the way it's written, where it says, where it goes from Memorial Day to Labor Day, and then they have 30 days. They can either do May or they can do September. So why can't they do both? I don't know why we're limiting it, is what I'm saying.
I think we talked about the weather the last time. You know, we do live in Maine, and we get some pretty good storms in September and early May.
I don't have a tent, so you have to.
Well, I don't have a tent either, but I have a lot of traps in the ocean, and it can get pretty nasty in May and September.
You know, we get storms, thunderstorms, heavy thunderstorms in June, July, August. So, you know.
But doesn't this read, Sheila, that if they want to, they can do it 15 days before Memorial Day, and they can do it 15 days after Labor Day?
Oh, certainly, but I'm just saying in September, you know, our season or fall season, it really extends itself to October, Columbus Day, and so you're taking away the month of September and into Columbus Day.
But haven't we put this, correct, I'm a little short on the history of this, but didn't we put this in because of the pandemic?
No, we had an ordinance. The ordinance said that places cannot have more tents up for longer than 30 days in a season. I don't even know why we have this ordinance at all.
Well, no,
We'd have tents everywhere.
Right, so
Yeah.
so let me just lend some clearance, and I'll ask Werner for any history, but currently we are allowing people because of the pandemic, and certainly having some more flexibility because of the pandemic, and if it continues into next year, this would be very beneficial. And what I heard from the state this morning leads me to believe we might see that. So one of the questions was, why do we have the 30-day window? And Werner, do you want to give any knowledge you have on why that was and where we are?
Sure. Yep. So so there's always been, you know, a reg on the books, you know, in the land use ordinance regarding tents as temporary structures. So we made amendments to this a number of years ago, where we went from essentially a limitation of an event, you know, which I believe was a 3-day event, which really only allowed folks to, you know, a day to put up, a day to have the event, and a day to take down, if you interpreted it that way. And so with feedback from a number of the hotels and restaurants, you know, we asked what was the amount of time that they needed, to have tents up. And so the 30 days was set really based on feedback from them that, over the course of a typical year, of course, not a pandemic year, that 30 days, generally worked for them, in terms of, the amount of time that they would have tents up for, weddings or other outdoor events. And so these modifications that you have here, in front of you is a modification, based on your requests to broaden, the allowances, for tents. And so having the 2 dates was really just intended to have as bookends, to say, if you want to have a limitation on here, then there should be some type of a season established, whatever that happens to be. I mean, that could be, it could be the beginning of May, it could be till the end of September. And then the other language that's in there just is an attempt to address what do we do with, the time frames that are beyond that, Labor Day to Memorial Day or May to September time frame, because if you don't address how you deal with the rest of the season, then it leaves us just in a bit of a quandary about what do we do with that then. So that's that's what the language was intended to convey, but certainly it's since, the request, I believe came from the selectmen, to make, propose some modifications, we can put whatever dates in this proposal that you would like.
I'm good with it as it's written. We went
Yeah, I
from
am.
30 days to, I agreed to 60. Now we're at 90, and that's as far as I'm willing to go.
Yeah,
Why? Why?
Because we have an ordinance, and if an
Why?
establishment has,
It's
you're-
not making any sense to me. Why do we,
well, why don't we just say year round then?
well then, why would somebody put up a tent in January?
Well, why would somebody be opposed to taking their tent down at the end of the summer? I mean, we had an ordinance that said 30 days. And now I feel as though every time I turn around, we're not you, but this is being stretched out. And this is as far as I'm going.
But why is this hurting you? Who is this hurting? So that the Nonantum could have their tent up from mid-May to mid-September or even October. Does that hurt you? What is that hurting? Why do you say that we have to have a limit?
Because the ordinance had a limit before.
Say that
And that's
again?
the point. Why?
I don't know why. I didn't make the ordinance.
I think some of the concerns is that if you read the ordinance definition of a structure, that a tent would qualify as a structure based on that pretty broad definition. And so what you have is you've got a list of exemptions, so you define structure and then you have exemptions. And so, this allowance for tents lives in kind of a world of an exemption, from that definition. Otherwise, if you don't have anything that really defines how you deal with it, if you just are silent on it, then there's a pretty hefty argument to be made that they have to be treated as structures, which means that locations like the Nonantum wouldn't be able to have a tent at all because it wouldn't meet a water body setback. And so, having some kind of an allowance for a temporary structure, which is really what you're saying here, allows for them to do that and not have to deal with lot coverage or setback issues or things of that nature.
And state laws and regulation as well, so.
Right, because otherwise, the unintended consequence I think that you have is that you wind up with tents that are of any size anywhere on the property for an undetermined period of time.
We've all seen our ordinances abused in ways that were unintended. And to Warner, I think Warner summed it up perfectly. So my answer to you, Sheila, is that each business has a specific footprint that they can conduct their business in. Therefore, their business is limited by the size of their establishment. And if we allow these tents, which are quasi-unregulated, as Warner said, they go in places that we would not allow a permanent structure. We're allowing them to expand their business. And while I am pro-business, I am not laissez-faire. So,
And I think the other thing with what Ed is saying is also true. It comes up when somebody comes and applies for their victuals, for their licenses for bars and so forth. They're only allowed so many seats, and within the establishment, so many places. So this, in effect, expands in a non-pandemic year. This expands their capability to have more seats than are allowed by their permits. Now, I haven't seen an additional permit come in for any of these additional seats. Maybe we have. I haven't seen them, but if, for instance, just use an example of like restaurant A has got an allowance right now or an authority for 120 seats, and then they go and add another 100 seats for tents or whatever it is, 50 seats, doesn't matter. Then we have another ordinance that is bypassed. So I think Ed's right. And I think that having 30 days leeway, you could have 15 days before and 15 days after. I think that's not a bad ordinance.
If we really looked at it, Sheila, we probably shouldn't allow them at all.
Pat, do you have anything to say? You haven't said a word.
Well, I'm hearing the pros and cons because, I see the potential on each side. We're trying to make it business friendly. I hear what, Ed is saying as well, where you don't want to just open the door and let them do whatever they want. But, I think a reasonable amount of time is necessary. So, something close to what we've already laid out here is something I'd like to see us continue with.
Well, I make a motion that we accept it as read right here.
And I'll second that.
I have a first and second. Any more discussion on this? Okay. Excuse me. I'm going to do a roll call. Sheila,
Nay.
Pat,
Aye.
Ed,
Aye.
Mike,
Aye.
Alan says aye. 4-1. Motion carries. Excuse me. Item 8, update on July 14th election and July 18th town meeting. I know that Tracy's already touched on this, but maybe you want to touch on it again.
I think I jumped the gun. I forgot I had my own agenda item. So basically, I've already covered it, but I'll just recap in case people weren't on the call at the beginning. The location for Tuesday's primary is going to be at Consolidated School Gym, not the fire station as usual. There are possibility of 4 ballots. If you're enrolled in the Republican or Democratic Party, you will get a party ballot. And then everyone will get a state referendum ballot, the local ballot for school board and board of selectmen, and then a ballot for the school budget referendum question. And we're asking people to wear masks. The workers will also be wearing masks at the polls, just